others, and Nokia Corporation and others.
Mr. Sigan.
My Lords, I appear with Mr. Mehta and Mr. Adekoya for the appellant, Amazon. Mr. Moody Stewart and Mr. Eustace appear for the respondents, Nokia. In terms of papers, the court should have a core bundle which runs in hard copy to 2 volumes, a supplementary bundle which is 1 volume, and an authorities bundle in 2 volumes. The court will, I hope, have received the supplementary skeleton from Amazon, which was filed on Tuesday afternoon in accordance with the court's timetable. That should have been added at tab 39 of the core bundle.
And to be clear, you seek permission for that?
My Lord, Lord Justice Arnold gave permission.
Oh, did I? I'd forgotten that.
So,
thank you for reminding me.
In advance, in a direction. I'm sure I'll be given the date. But
Lord Justice Arnold doesn't seem to be dissenting, so suffice.
Indeed, my Lord. A short point in relation to confidential information. A certain amount of confidential information in the bundles has been highlighted in red. It relates principally to the details of the parties' offers to each other in negotiations. Very little, if any of it, is likely to be material for the purposes of today's argument. But to prevent any loss of confidentiality, we would ask the court to make a pro tem CPR 31.22.2 order to protect the confidentiality of that information. We have been able to agree a wording, subject of course to the court's approval. I can either hand the draft up now or we can send it at lunchtime.
How long is it just to read through?
It's not very long at all.
Can we just hear it?
Indeed, yes. It may be easier actually if I hand up the copies.
Good idea, yes.
I would assume it's in standard form.
It is. It's in the form that is very often made in these cases. The version that the court has, regrettably, has one completely immaterial track change in the recital. But the substance is in paragraph 1 on page 2.
Yeah. So I think assuming that Lord Justice Snowden is happy, we're happy to make an order in that form.
I'm most grateful, my Lord.
However, while we're on the subject of confidentiality, I'm bound to say that I'm troubled that some of what is contended to be confidential, I'm not at all sure is confidential. Moreover, I find it difficult to see how we're going to be able to give a coherent judgment without referring to some of this information. Now, the example that is top of my list, I'm afraid, comes from Mr. Moody Stewart's argument, but the point applies to both sides. This is not a point that is unique to one side or the others. The example that I'm going to give you is paragraph 4 of Nokia's skeleton argument. And there is a sentence in the middle which, as I understand it, is covered by confidentiality. Now, at the moment, I find it difficult to understand how that can possibly be confidential. Moreover, as I say, I find it difficult to see how we write a judgment on the basis that that is confidential. But thirdly, in any event, can it not be dealt with? The sentence in question is partly, but not entirely, expressed in terms of it being a fact. But if we say it is alleged that, would that still be objectionable?
My Lord, I think I could. There are probably two concerns there which I'll deal with sequentially. The first is in relation to the content of the judgment. And of course, the order which we have sought and the court has approved to make is a pro tem order pending further order of the court. And so if it is the case that there is any confidential information which is central or material to the court's determination, then of course the court can then make a different order if it sees fit. So it certainly doesn't in any way seek to restrict the content.
Of course, but that just deals with the interim order.
Yes.
The question will then arise at a later stage.
Yes, my Lord. And that then brings me to the second aspect of my Lord's concern in relation to whether this information, by way of example, is conceivably confidential. And respectfully, I would agree that at the level of generality with which it's expressed in paragraph 4, it seems very difficult to see how that is confidential. And I suspect that the reason it has been highlighted may be because the detail of those offers is said to be confidential. But of course, ultimately, it's for Mr. Moody Stewart.
Yes,
but,
well, of course, one can appreciate that details may well be confidential.
Yes, but my Lord, as I say, respectfully, I would agree that at that level of generality, it seems difficult to see how that is confidential.
Can I raise a sort of follow-on point from that, which is that the form of order, paragraph 4, which you've now put in front of us, talks about the documents designated as confidential shall remain confidential, whereas a considerable number of them, including the one we've just been talking about, it's not the documents which are confidential and must remain confidential, it's only those parts which are identified as. And so the order itself is too wide. Because, I mean, it's a matter of open justice. For example, anybody sitting in the court ought to be able to have access to the skeleton arguments. Now, you may say that certain phrases or footnotes might be obliterated in any copy seen by anybody, but it can't possibly be the case that the whole document must remain confidential. I don't think that's. I assume that's that's not what's intended, but nevertheless, the order appears to suggest that.
My Lord's point is a fair one, and I think, having heard it, clearly the order requires a bit of adjustment to say the parts of the document designated confidential.
The schedule obviously seeks to draw the distinction because it has entirely confidential documents and it has other documents with confidential information indicated by various colours.
Yes.
So the concern is whether that designation in the schedule is itself sufficient or whether it needs adjustment in paragraph 1.
My Lords, may I hope, help at this stage, though one's always a little hesitant. So in relation to the specific sentence we're talking about, just the information that is of concern is that which is in the footnote. So the designation of the sentence which just refers to those offers, there's then a footnote which says more detail about what those offers actually comprise, which then leads into issue.
So we concede on the basis that the body of paragraph 4, the sentence is not confidential. What is confidential is the detail in the footnote.
My Lord, yes, but that to be absolutely fair is that deals with the specific point and not the more general issues that are arising here and which do need to be grappled with. So in terms of the designation of documents as confidential, my understanding is that redacted versions of all the documents that are designated confidential, so non-confidential versions of them that are suitably redacted, are available. And so the order saying that the documents that are designated are confidential.
It means that version.
It means that version. And indeed, this leads to the slightly peculiar outcome that when a redacted version of a confidential document is prepared, the first thing that's redacted is the word confidential at the front, which always has me scratching my head. But that then means it's no longer said to be a confidential document, and so it's free to go. So, my Lords, you're absolutely right to raise this as a point of detail, and the principle of open justice is very important.
So what I propose is that when it comes to the judgment, we will adopt the usual procedure, namely that we will write our judgments as we see fit. And when the draft goes to the parties, obviously it will go under embargo, and the first thing you will do is to check for confidentiality issues, and hopefully there will be none at that stage, but if there are, that will have to be addressed before the draft is then considered further.
Yes, and we'll obviously cooperate in that process.
Just to pick up the further point, is it the case the entirety of the document number 7 in the first bit of the schedule is confidential? Because it just says extracts of. I don't understand why. I don't understand why it's an entirely confidential document, but it is only identified as having extracts. And in fact, if you look at the document, there's no indication as to which bits it is confidential.
My lord, perhaps I can pop up on that one as well. The version, so the extracts that are in the bundle are the only extracts that are relevant to the issues today. This is the Munich judgment, and the Munich judgment was prepared on the fully unredacted version is said to be confidential. Now, looking at the things that are redacted, because there is a redacted version and an open version, there are some things that on their face seem to me very unlikely to be confidential, but that's the approach that the German court has taken in doing so. What is in the bundle is the unredacted confidential extract from that. The matters that are generally confidential within that, as marked up by the German court, the Munich court, are dates, values, information concerning particular offers. My lords, there is a redacted version of the judgment that unfortunately is not in the bundle, but we can provide the redacted version of the extract that is behind that tab, so the parties can and the court can see what is confidential within there. But
okay, I've sort of lost you.
Sorry, my lord, that's my fault.
I was only really sort of concerning myself with the point that presumably any confidentiality which you seek goes no further, but no less than the German court's own
my lord,
view
yes.
of confidentiality.
My lord, yes, that's certainly the and your lordship's point about the extract. The extract is not coterminous with confidential. It's not. It's the extract is the unredacted version. It's an extract on the basis of relevance, because otherwise it's a very long judgment, and so we haven't put in all the bits of it. So the confidentiality, the reasons that we say the Munich judgment is confidential is because, as a matter of the German court's procedure, they have said this is confidential, and they have produced a redacted version, which is not confidential. But unfortunately, when you look at the redacted version, because redacted are things like figures and dates and things that would allow you to identify what offer they're talking about at what particular point, it renders quite a lot of the German judgment incomprehensible, as one sees from the ALJ, the Administrative Law Judgment, which is in its redacted form, which is pretty hard to follow, given the scope of the redactions. And my lords, I apologise that the redacted version is not in there in the bundle, so we can see it. We can provide that over lunchtime.
I mean, I suppose the immediate question is, I said a moment ago that we were happy to make an order in the terms of the draft that you've agreed.
Speaking for myself, I still have no problem with it.
Well, I'm obliged. Sorry, I'm obliged to my Lord Justice. I'm certainly not seeking to prevent my lordship from telling me that.
I mean, I can see how it could be tweaked in certain respects, but maybe it doesn't really need to be.
I mean, this isn't the only forum in which this sort of issue arises, and I'm bound to say I do have a problem from an open justice perspective of an order which is ambiguous as to the extent to which documents are in fact confidential. And if in fact it's just the highlighted bits that are confidential, then I think at very least the order ought to say so. Speaking for myself.
Could we just clarify there seem to be two potential issues. There are the documents in the second half of the schedule where it's other documents with confidential information indicated by such and such. So that on the face of it, I would understand this is relating only to the bits that are coloured.
That's how I would understand it and think it ought to be clear from paragraph 1. And I'm afraid in other cases, in other contexts, this very point has led to difficulty, simply because people have been unsure about whether what it is simply the highlighted parts or not. And in that context, people have come and said, for example, the media, in another case I dealt with, we want to have, please, the skeleton arguments of counsel subject only to the redactions.
Yes, and my lord, for the avoidance of any doubt, that is absolutely what is intended. There's no suggestion that the skeleton arguments should in their entirety be confidential.
To be on the safe side,
Yep.
would it be possible for the teams, since you seem to have adequate legal resource here,
Yes.
to produce something that is unambiguous by, say, 2 o'clock?
My lord, we will do exactly that. Or at least endeavour to do exactly that, given the standard that's been set.
Thank you very much.
My lords, with that, by way of introduction, let me turn to the substance. This is an appeal against, as the court will have seen, an order of Mr. Justice Zaccaroli, as he then was, dated the 10th of September 2024. And by the material part of that order, the judge refused permission for Amazon to amend its pleadings so as to introduce a claim for interim licence declarations and associated relief by way of specific performance. Now, let me emphasise at the outset, therefore, what we say is the correct and indeed the only question for the court. This is an appeal concerning the amendment of a pleading. The issue is simply whether Amazon's claim for an interim licence should be permitted to be pleaded so that it can be heard on its merits in due course. This is not an appeal against a final order determining the claim for interim licence relief which Amazon wishes to plead. And that being so, the correct and indeed the only substantive question for the court is whether the amendments which Amazon wishes to plead have a real prospect of success. Now, in that regard, the judge, writing his judgment in July last year, without the benefit of the decision of this court in Panasonic and Xiaomi, held that the amendments had no real prospect of success. And as the court will have seen, his principal concern was that he could not see how one got from what he described as the premise of a RAND licensing obligation with its associated duty of good faith to the consequence of an arguable obligation to offer an interim license. And his reasoning in that regard was, as the court will have seen, understandably short, it being contained in a judgment which dealt with a large number of other issues. Now, having formed that view, the judge refused permission to amend, but as the court may have seen, he also extended time for seeking permission to appeal against that determination until 21 days after this court had delivered its decision in Panasonic and Xiaomi, which at the time was pending. He was, in our submission, wise to grant that extension. The Panasonic and Xiaomi decision was delivered on the 3rd of October last year. And in a nutshell, we submit that that decision, in effect, answers in some detail the judge's concern. It explains precisely how the premise of a RAND obligation and associated duty of good faith can indeed lead, in an appropriate case, to a duty to offer an interim licence because that is what a willing licensor in the circumstances would do. And that decision in that regard broke new ground. With the benefit of that decision, we submit it is clear that Amazon's pleading does indeed have a real prospect of success. There is no knockout blow which renders that claim bound to fail. This is a case, as we shall be seeing, in which these English proceedings are the only proceedings anywhere in the world which will actually be determining and settling global RAND terms between these parties. Indeed, the judge decided, and there's been no appeal against that decision, to expedite the RAND determination to a trial which is listed in a window starting on the 6th of October this year. And as we'll be seeing, he did so precisely because that was the only way to address what is the real underlying commercial dispute between the parties here, which is what are those global RAND terms. Now, having successfully sought that determination from these courts in these proceedings, Amazon has committed and undertaken to enter a licence on whatever RAND terms are set by the court. And Nokia has thereby secured, we submit, all that a SEP owner could legitimately wish to secure in the event of a crystallised dispute about RAND terms. Nokia has a guarantee that Amazon will enter into a licence on RAND terms determined by an independent court, which is indeed the only court seized by either of these parties that will actually be determining such terms. And yet, Nokia nevertheless continues to seek and to enforce patent injunctions against Amazon in as many different jurisdictions as possible. Indeed, even after Amazon had already given an unconditional undertaking to enter a licence on whatever terms are RAND, Nokia chose to obtain and enforce an injunction in Germany, the effect of which is that Amazon is currently prohibited from selling devices like Amazon Fire Sticks in Germany. And that is despite Amazon having already undertaken to take a licence on whatever terms are RAND under all of Nokia's SEPs, including the very SEP which underpins the injunction in Germany. Now, we say it is very well arguable, which is all that matters for present purposes, that the only sensible reason Nokia can be behaving in this way is because it wishes to use the commercial harm caused by patent injunctions to force Amazon into terms better than those which Nokia expects the court to settle at the RAND trial in October. Why else, we ask, would Nokia be spending millions of dollars on infringement litigation in numerous jurisdictions all around the world? And against that background, we say Amazon's claim for interim license declarations and associated specific performance clearly has a real prospect of success applying the reasoning in Panasonic and Xiaomi and deserves a hearing on its merits. Of course, the question of whether or not Nokia is actually in breach of its duty of good faith and the such like will all be issues for the trial of the pleaded case in due course. But there is certainly in our submission a perfectly good pleadable case for such relief, and the judge was in error in deciding otherwise.
Well, by definition, presumably there will be a requirement for an interim hearing before the final trial.
Yes, my lord.
So, I mean, you're not going to wait until the final trial to have the question of whether you're entitled to an interim licence determined.
No, certainly not. We would seek a hearing of our claim for an interim licence as soon as possible. And of course, the case management of our pleaded case will be a matter for the High Court.
But that does engage to some extent with one of Mr. Justice Zaccaroli's reasons for refusing the amendment.
Well, my Lord,
Which is the procedural ground, which isn't entirely covered, I think, by the Panasonic decision. I just put that point out there.
well, I think, my Lord, I think it's paragraph 90 maybe of the judge's reasoning. Certainly there is a final paragraph of his reasoning where he says, I would not in any event have listed a trial to determine an interim licence. And he has subsequently made clear in his reasons for refusing permission to appeal that he did not regard that as an independent reason for refusing permission to amend, as I'll show the court in due course. But in any event, the premise of that paragraph of his judgment is that the determination of an interim licence would require two RAND trials, as he puts it. And in my submission, that, and I'll be developing this in due course, but that point is fully met by the reasoning of the court in Panasonic and Xiaomi, which explains that that is not what the exercise of determining an interim licence actually entails. And the court in Panasonic deals specifically with that point. So it was on the misapprehension, with respect, that one would need somehow to duplicate the substance of the RAND trial. In fact, as the court makes clear in Panasonic and Xiaomi, at the point of determining an interim licence, one is concerned with a far more modest question of what are the appropriate terms to, in effect, to hold the ring between the parties until one gets to the RAND trial. My Lords, I wanted to develop the remainder of my submissions under 5 headings. The first is the background against which the appeal arises. The second is Nokia's procedural argument arising from Amazon's amendment to its interim licence offer. The third is the test for permission to amend a pleading. The fourth is the judge's reasoning and Amazon's appeal against it. And the fifth is Nokia's additional points, including the foreign decisions. So taking those 5 topics in turn, the first is the background against which the appeal arises. That is set out in the judgment at paragraphs 1 to 27, and we've developed a slightly more detailed account in our skeleton argument at paragraphs 18 to 43, with references to the evidence. As the court will have seen, there are essentially 2 parts of Amazon's business which are of relevance to the overall dispute. The first is devices. So that is the business selling video-compatible end-user devices, things like Amazon Fire Sticks. And the second is Amazon's business operating the Amazon Prime Video streaming service. Of relevance or potential relevance to both of those activities are the AVC and HEVC video compression standards promulgated by the ITU. It is common ground between us that decoding an AVC or an HEVC bitstream is an activity within the scope of the relevant standards. There's a dispute between Nokia and Amazon as to whether encoding the same bitstream is also standardized. We say it is, Nokia says it isn't. Now, the only potential relevance of that issue for today's purposes is on the case management arguments, which I'll come to in due course. Amazon's business in those connections also involves doing things which Nokia says infringe allegedly non-essential patents owned by Nokia, particularly in connection with essentially the organization of the streaming service. But Nokia certainly advertises its video patent portfolio to the world on an aggregate basis. We have an extract of its website in the first core bundle at tab 17. And at page 175 of the bundle, under the heading Industry-Leading Multimedia Innovation, we see that in the third paragraph under that heading, we have a leading portfolio of standard essential patents and a broad scope of non-SEPs that cover every main area of the AVC and HEVC standards. And then in the last paragraph on that page, in addition to video compression, Nokia has a number of fundamental implementation patents that enable key technologies in streaming or over-the-top video platforms, etc. So it is advertised as being a comprehensive portfolio. And Nokia has a history of licensing other implementers on a holistic basis which covers the whole portfolio. We've set out that in some detail. I don't need to go into it, but it's in the Part 20 claim at paragraphs 13 and 45A, and there is a whole annex to Amazon's FRAND statement of case at Annex 8. Now, Amazon had a pre-existing license with Alcatel, so there is then a dispute about precisely what that license did and didn't cover, which this court, again, doesn't need to be concerned with, but it's part of the background. This is certainly not a case where Amazon had no license at all. Despite discussions having been ongoing for some time, Nokia had not, until shortly before commencing these proceedings, made Amazon an offer in relation to its streaming service. But Nokia's current position is it is willing to grant a license or licenses which cover the whole of its video portfolio. That's the defence to the Part 20 claim at paragraph 27. There is, as I say, a dispute about whether Nokia is legally obliged by RAND to license anything other than the decoding claims. But the judge determined, as the court may have seen, that it was arguable that Nokia is indeed obliged to offer the whole of its video portfolio, principally based on the non-discrimination obligation, given the scope of the licenses which Nokia has granted to others. And there is no appeal against that determination. The sticking point, as is so often the case in these cases, is not whether Amazon should take a license, but rather how much it should pay. Nokia has made offers which Amazon intends to say at the RAND trial cannot be reconciled with the best benchmarks available, which are the pool rates offered by MPEG-LA and Access Advance. There is a crystallized dispute as to the rate. And what happened is then just days after making that first streaming offer, Nokia commenced what can only be described as an extraordinary array of proceedings against Amazon seeking patent injunctions, which would exclude Amazon from many of its largest markets.
Why is it extraordinary?
It's extraordinary in its scope, my lord. Amazon is faced with, and we summarise it in paragraphs 23 to 34.
But is it just a function of the fact that Amazon operates in many jurisdictions?
Well, my lord, these RAND and FRAND cases are usually between multinational global undertakings who operate in lots of different jurisdictions. It's not uncommon for proceedings to be commenced in more than one jurisdiction, but equally the extent of the campaign in this case is really quite exceptionally broad. And if one looks at the reports, it must be amongst...
Exceptionally broad, having regard to Amazon's operation, or just...
having regard to these cases, generally, my lords. At any rate, leaving aside the question of whether it's exceptional or extraordinary, it is certainly very broad indeed. We summarise it in paragraphs 23 to 34 of our main skeleton. In Brazil, Amazon is faced with proceedings on one SEP and a preliminary injunction has already been obtained. In Germany, Amazon is faced with claims on 2 SEPs relating to devices and 3 NEPs relating to services and devices in 3 different German courts. And as I've explained, Nokia has already obtained an injunction on a SEP, even though Amazon had undertaken to take a license on RAND terms in relation to the SEP portfolio. In the ITC, Amazon is faced with 7 SEP infringement claims accusing devices. In the UPC, 1 SEP accusing devices. In India, 2 NEPs accusing devices and services. In Delaware, 20 SEPs and 6 non-essential patents accusing devices and services. And here in the UK, 3 NEPs, which are system or method claims relating to the Amazon Prime service. And the common thread of all of those proceedings is that none of them sought a determination of global RAND terms between the parties. That is so, even though Nokia knew and knows very well that there is no dispute about whether Amazon should enter a license, only a dispute about the terms thereof. And my lords, to try to bring about an end to this hugely wasteful and harmful state of affairs, Amazon sought, by way of counterclaim in these proceedings, a determination by the court of global RAND terms between the parties. In relation to that RAND determination, we make an important point in Amazon's supplementary skeleton at paragraph 8. And the point is this: the global RAND determination arises in these proceedings for 2 distinct reasons. First of all, it arises because it is part of Amazon's defence to Nokia's claim for an injunction on the non-essential patents asserted in the UK. That is the point determined to be arguable by the judge in paragraphs 51 to 69 of his judgment. Essentially, that the RAND license which Nokia is obliged to offer Amazon under its SEPs would cover its NEPs in relation to the video service and therefore the patents in suit in the UK. So that's the first way in which global RAND arises. But it also arises, as we point out in that paragraph of our supplementary skeleton, as part of Amazon's own positive case founded upon 2 of Nokia's UK SEPs. Now, we've given you the references to the pleadings. Amazon has put at issue 2 UK SEPs owned by Nokia and has sought the declaration of the global RAND terms, or the RAND licensing terms, applicable to those 2 UK patents, which we say will inevitably be, following Unwired Planet, the global RAND terms. And I've given my lords in the skeleton argument a quotation from the judge's judgment finding that that claim for a determination is part of Amazon's claim for a declaration of non-infringement in relation to those patents. So the need to determine global RAND arises not just as part of Amazon's defence to Nokia's claim, but also as part of Amazon's own counterclaim focusing on 2 of Nokia's UK SEPs, which have been put squarely in issue. Now, Nokia sought to prevent that claim for a RAND determination proceeding in the UK. they said it should either be struck out or that the court had no jurisdiction over it. But that invitation failed and there has been no appeal. And to the contrary, the judge decided to expedite the RAND trial to October 2023. And his reasoning in that regard is in his judgment at paragraphs 139 to 142. Now, in the recitals to the order under appeal, Amazon gave an unconditional undertaking to enter into a license on whatever terms are determined to be RAND. It's worth just showing the court that. It's at Core Bundle 2, tab 34, page 197. And next to the lower hole punch, in fact just below the lower hole punch, we have a recital beginning, and upon Amazon undertaking. It's the fourth up from the bottom. And indeed the next recital concerns undertaking to exercise the option to take a license in respect of NEPs if that is what the RAND license would contain. And as I say, these are the only proceedings worldwide which will actually undertake that exercise of determining RAND terms between the parties. In its skeleton argument, paragraph 77C, Nokia complains about the lapse of time between now and the RAND trial. But we submit that that is a hollow complaint in circumstances in which Nokia has done essentially everything it can to delay a RAND determination proceeding here in the UK. It not only challenged jurisdiction but also opposed expedition. And had it not done so, we could have been having a RAND trial even more quickly. But against that background, what that means is that we now have a situation whereby there will be a RAND determination resolving the parties' real commercial dispute. These proceedings are the only ones in which that exercise will take place. And Amazon has undertaken to take a license on whatever terms the court sets. And in those circumstances, we say there is a case with a very real prospect of success that a willing licensee, acting in accordance with its duty of good faith, would enter into an interim license to allow that process of RAND determination to take place in an orderly fashion, rather than continuing to enjoin Amazon around the world. Now, I shall of course come to Panasonic and Xiaomi in that regard, but let me first show you the draft pleadings. What we've done in the Core 2 bundle at tabs 32 and 33 is to mark up on the existing amended versions of the pleadings for which permission has already been given, those amendments, and only those amendments, in relation to interim license for which we sought and seek permission. And the reason, what you will see at tabs 32 and 33 is that there are green amendments. Those are amendments for which the judge has already granted permission. And there are then purple amendments. By way of example, the first first substantive one in the defence at tab 32 is at page 162 in paragraph 36. One can see at the end of 36, Amazon further seeks a declaration of the terms of an interim licence as set out in paragraphs 52b, etc. Now, those are the same amendments for which permission was sought from the judge But the reason we've marked them up in this way is so that the court can see immediately the amendments which are in issue on this appeal, as distinct from the amendments for which permission has already been granted by Mr. Justice
And just to be
Zachary.
clear, when you say they are the same amendments, you mean all the purple changes?
The purple.
Not merely those two that you...
No, indeed, my lord, all of them.
Yeah.
As regards the defence and counterclaim, the amendments are relatively modest. There is that paragraph 36, which just lays the foundation for the interim licence case. There is paragraph 45A on the facing page, where a point has been added about Amazon's enforceable contractual rights to be offered a licence, including an interim licence. And then the declarations are at page 165. The substance of the claim for an interim licence is then set out in the Part 20 claim, which is in the next tab, tab 33. And for the purpose of explaining the argument, I need to show the court, first of all, some parts of the pleadings which are already in there and for which permission has already been given. If one goes to page 174, in paragraph 23, Amazon recites that Nokia had commenced multiple legal proceedings, etc., and then sets out the detail of those proceedings in paragraph 24, which is defined as the Nokia 2023 litigation. Paragraph 25 makes the point that none of the proceedings within that litigation seek a determination of the RAND terms. 26 makes the point about the RAND license extending to the whole portfolio. And 27 pleads, and permission has already been granted for this, is already there, that in circumstances where the means of resolving the real dispute between the parties is available to Nokia in these proceedings, the only possible purpose of the Part 20 defendants refusing to undertake to offer a RAND licence as aforesaid and continuing to seek injunctive relief against Amazon is to apply improper commercial pressure to Amazon in the negotiation of a future licensing agreement with a view to extracting excessive and or super RAND royalties in respect of the Nokia video portfolio, contrary to their obligations arising from their RAND commitment. We can then turn, my lords, to paragraph 32 on page 176. That is the pleading, which again is already there, that by completing the declarations, Nokia Corp and Tech entered into a Swiss law contract whereby they are bound inter alia to enter into good faith negotiations in respect of and to offer worldwide licenses to the Codex EPS on RAND terms. Now that paragraph 32.1 is admitted by Nokia at paragraph 35A of the defence, with the only relevant caveat being that they dispute that the obligation to enter negotiations and to offer RAND terms are separable. But we, for our part, don't understand the significance of that point. At any rate, the principle that there is an obligation to enter into good faith negotiations in respect of and to offer is admitted and is common ground. We then, at paragraph 34 on page 177, have a pleading that the remedy of specific performance is available and that Amazon is a beneficiary. The point about being a beneficiary is further explained at paragraph 40 on page 178. And here the court, just to pause for a moment, the court will see under the heading the challenged patents, this is where the putting in issue of Nokia's own SEPs begins. But in paragraph 40, one sees the pleading that Amazon is a beneficiary and is entitled to a RAND license covering the challenged patents. And that's explained throughout paragraphs 40 and 40A. The interim license part of the pleading we can then find at page 186 onwards, at paragraph 52B onwards. Now the green is, these are paragraphs which are already in the pleading. So we have at 52B the definition of the injunction claims. At 52C, the point that if Amazon is licensed, there won't be an injunction. And even if it's not licensed, foreign courts will take into account the efforts to reach a licensing agreement. At 52D, we have a pleading which is already there, that it is averred that Nokia's continued pursuit of injunctive relief in the other injunction claims, in circumstances where, and then they're set out, can only have the purpose of placing undue commercial pressure on Amazon to conclude a license on supra-RAND terms before the English court is able to settle the court-determined license, and does place such commercial pressure on Amazon. It is averred that Nokia's conduct in this regard is inconsistent with the Part 20 defendant's obligation to perform the RAND commitment in good faith. So in fact, the breach of good faith is already pleaded. 52E, the point is made that if injunctive relief is granted prior to RAND terms being settled, then that injunctive relief will prevent activities that once the terms of the license have been set would have been licensed. And as a result, those activities will have been carried out with the retrospective permission of the proprietor. So that's all in already. And then the part for which we seek and sought permission begins at 52F. In the aforesaid circumstances, which of course include the litigation, the breach of good faith and the such like, which I've already shown you, it is averred that the RAND commitment instead requires Nokia to provide Amazon with a means to be licensed to the Codex SEPs pending the resolution of the RAND trial at first instance by agreeing to entering into an interim form of the court-determined license as described below. 52G sets out what are, we say, the characteristics of the interim license. 52G.1 says it will have the non-royalty terms set out in the draft license provided to Nokia on 17th of May 2024, as amended from time to time. Now, just pausing there, that reflects the fact that in all of these FRAND cases, as what we'll be seeing, for instance, from the judgment in in Panasonic and Xiaomi, the parties' offers evolve as one proceeds towards a hearing. Indeed, in Panasonic and Xiaomi, Panasonic's, as we'll see, Panasonic's first offer of an interim license was made after argument in the Court of Appeal on a final appeal. And the reason that this is there is to embrace that fact that the offers will inevitably be updated as one approaches the hearing. We then have the royalty set out in 52G.2, which I shan't read because it's in red. That figure has, as we will be seeing, been significantly increased in the updated offer. Then provision for all terms of the interim license to be adjusted with prospective and or retrospective effect to reflect the final form. 52H is that a willing licensee should have the right or ability to apply for a determination of interim terms. 52I is the willingness to give undertakings to take.
Craig, can I just take you back?
Yes, my lord.
Just it may not matter, but I'm just struggling to understand the explanation you gave about the as amended from time to time. Once there's been an interim license entered into on such terms as are in the interim license, are you saying that it's a rolling interim license and that it has to be updated?
No, my lord.
So I don't really understand. It's required to enter into a license on non-royalty terms set out in the draft. What you mean, as amended subsequently?
I'm sorry, my lord, but perhaps that's not as clear as it could be. But I think because it is from time to time by reference to a draft license, it is amendments from time to time to the draft proposed by Amazon to its offer.
But your obligation is that presumably your obligation is that, sorry, your argument is that the obligation kicks in when the very first draft is offered.
Well, in fact, my lord, as we'll be seeing in Panasonic and Xiaomi, what the court has said.
I know what happened in that other case. It was a rolling.
No, sorry, my lord, a slightly different point. What the court says in Panasonic and Xiaomi is, in fact, that the implementer is entitled to a license from day one, from the moment that they start implementing the standard. So I think that's the position as a matter of law.
Yeah.
But what this is intended to encompass is simply the fact that it is in the nature of these FRAN cases that in advance of a hearing as to what the interim license terms should be, it is very likely that the parties' offers will evolve.
But that's not what this says. I mean, I understand the point you're making, that there seems to be a commercial negotiation going on outside court. But this seems to, unless I've misunderstood the drafting, it says you have to enter into, that the obligation kicks in when the draft license is provided on the 17th of May. And presumably it continues every time another offer is made. I don't quite...
No, my lord. I think, first of all, to answer the point that my lord made about whether there would be an amendment after the court has settled interim licence terms, that is certainly not the purpose of this. Of course, if the court has determined interim licence terms, then that's the end of the matter, subject to the RAN trial where it's all adjustable.
Yeah.
This paragraph is certainly not intended to connote anything other than that Amazon says that Nokia must enter an interim license, and that Amazon's case is that it will have the following terms. And those terms are the draft of the 17th of May as amended from time to time, reflecting the fact that it is in the nature of these things that Amazon is very likely to make an updated offer prior to the hearing of interim license terms. And that is all that this is intended to connote. Of course, it's for the court in the end to decide what the interim license terms should be, and they're very unlikely, although perhaps in this case, for reasons I'll be coming to, perhaps they will, but they're unlikely to reflect the terms proposed by either side. They're very likely, in the ordinary course of things, to be a compromise between the two, as they were in Panasonic and Xiaomi. Uh, 52J pleads, unless the Part 20 defendants agree to abide by the terms of the offer, stay the pursuit of injunctive relief and not enforce, then Amazon will ask for declaratory relief. 52K sets out what the useful purposes of that declaratory relief would be. (52L) makes a similar point to that in 52E, which is already there, and 52M is the plea for specific performance. Which we say is available under Swiss law as a result of the provision of the Swiss Civil Code, which is pleaded earlier in the pleading.
And again, on your view of the world, 52M would be determined at the, so to speak, interim hearing in advance of the full trial.
Yes, my lord.
To a high degree of assurance.
The high degree of assurance was certainly the test laid down by the court in relation to the question of whether interim licence declarations should be granted. Of course, the court wasn't expressly dealing with an ancillary claim to specific performance. It may be argued, I'm sure my learned friend would argue, that the logic of applying the high degree of assurance standard would apply equally to a specific performance claim.
Can't be lower than that, can it?
I'm my lord, I don't want to concede that point here.
There's an argument you must go further than that, which I think was the point of my lord's question. But it can't be lower than high assurance, can it?
My lord, I'm sure it will be said, as I say, that the logic applies equally. I won't.
You're not instructed to concede the point.
Quite, but yes.
But you are seeking a mandatory interim injunction, in effect.
Well, my lord, it's true that that claim for specific performance would involve the court ordering Nokia to comply with whatever it has determined is its RAND obligation at that stage. It would only involve ordering performance of that obligation insofar as it relates to an interim licence. We're not talking about anything broader than that. And of course, there will be an argument about that. If my learned friend wants to say that that's disproportionate or shouldn't happen, of course he can make that point. It's in a sense, it's an additional point over and above Panasonic and Xiaomi anyway, because Panasonic and Xiaomi was a case about the ETSI-FRAND obligation, where no specific performance is, or traditionally people have thought that no specific performance is available. And nevertheless, the court found that simply granting declaratory relief served a useful purpose, because if Nokia, or in that case Panasonic, is really a willing licensee, and the court declares what that obligation entails, then one at the very least hopes that the responsible licensor will reconsider its position and will grant those terms. So specific performance is not a necessary part of succeeding on the interim licence. It is an additional component of the claim.
Where does the specific performance order that you seek, as in 52M, where is it reflected in the preferable?
4C, I think.
Many others in the court have got there before me.
What, an order
Yes,
that Nokia offer Amazon? You know, it's the words "and enter into the same" that I'm...
Oh, I see. My lord, that arises because of a specific point arising from a case called Nokia and Oppo Trial F.
Okay, if it's not an important point following on from my lord's question to you, let's not go down there.
Okay, it's actually a relatively short point. In that case, Mr. Justice Mead determined that the effect of the ETSI obligation, strictly speaking, was not an obligation to grant a RAND licence, but rather to make an offer of a RAND licence capable of acceptance. Of course, in practice, that makes little difference because the willing licensee will then accept that offer. But that is why it's framed in that way.
Yeah, it's just that your 52M doesn't match 4C. That's all. That's just all I was asking. The words "and to enter into the same" don't appear in 4C, and I just wondered why.
Yes, and it's a fair point that my lord makes, because in fact 52M.2, giving the particulars, refers only to entitled to enforce the requirement to make a RAND offer. But I don't, that is not in my submission in the end material, because if they are obliged to offer it,
right, okay,
then clearly if it's RAND and we've undertaken to take it, the effect is the same.
Yep.
My lords, that brings me to the second of the 5 big topics I wanted to deal with, which is Nokia's procedural argument. And the court will have seen that Nokia spends quite a lot of time in its skeleton argument advancing a submission that because Amazon amended its interim license offer just over a month ago, in fact, to bring that offer into line with what Nokia has itself offered in the past, somehow that renders the amendment application a different application, which is not properly the subject of an appeal. Now, that argument arises because of a letter which Amazon sent updating its interim license offer more than a month ago, on the 12th of December 2024, which the court will see at supplementary bundle tab 20, page 336. And as a precaution, given it's not clear to me precisely which bits of this are and are not confidential, I perhaps should just ask the court to read this letter. And my lords, we submit, in short, that the suggestion that the making of that revised offer creates some kind of procedural objection to the pursuit of an appeal against the refusal of permission to amend the pleading is, we say, unfounded. We deal with this suggestion in paragraphs 10 to 16.
Just before you go into the arguments, what you originally wanted was based on the 17th of May offer set out at Annex 5, which we have at core tab 26. Just so I'm clear, how much of that letter survives?
How much of the...
Well, I mean, what you're pleading at the moment is that you want terms set out in the draft license, which we see at tab 26,
Yes.
as amended. Well, which bits are amended? Or is it all gone, in effect?
Well, what has happened is, because there was an offer, as my lord will have seen, and without going into the detail, in effect to mirror the terms that have been offered by Nokia themselves, I think I'm right in saying that much of the detailed terms of the license have changed because we're now offering the terms which they were prepared to.
And I follow the sense of that, but just in terms of the pleading, you say, well, nothing's changed because 52G.1 allowed for amended from time to time. And what I'm just querying is whether really that's what you're saying, or whether actually you're saying the terms should be based on a different offer. It's not a matter of amending the 17th of May offer, it's a different offer.
No, I don't. My own friend nods, and I can understand why he nods because of his procedural objection. But the reality of the situation is that the question was always what the interim license should cover and what the price should be. Those are really the two important things here. Our case as to what the interim license should cover continues to cover the SEPs, but it has been narrowed in the respect in which the letter describes.
So we can simply cross out certain parts of Annex 5, can we, and find what's left?
Well, my lord, what has happened, in fact, in practice, and I can, if the court wishes to see them, it can, but obviously terms have been sent to Nokia to reflect that. But they don't come as any news to Nokia because they are the terms that Nokia...
I follow the point of
Yes.
substance, but whether you can really hang on to 52G.1 seems a bit more questionable, because you're not proposing anything based on the 17th of May offer at all.
Well, my lord, we are, to the extent that the revised offer continues to cover that which the 17th of May offer covers, i.e. the SEPs.
Can I play catch up just for a second, because I'm just a bit slower on this one. Where is Annex 5 to the pleading?
It's tab 26.
Because if I put it as a compare-right document against the document that you're currently in, would I just get the two documents entirely, are they entirely different documents?
My lord, I haven't seen that compare-right, I have to say, and so standing here...
What my lord, I think, is saying to you is, look, that talks about a draft licence provided in the 17th of May.
Yes.
You're now talking about a draft licence provided pursuant to a letter of the, whatever it was, I've lost the letter, 12th of December. And my lord is just, I think, saying to you, hang on, it's not the first one as amended. It's a completely different document. And you're saying, yeah, but the terms are the same, they're just in a different format or whatever. Or they're different, but you can do a compare and contrast. But I think the point's taken against you is that actually it's not 52G1 as amended. It's a different document, but with some development of terms.
Well, my lord, of course, one needs to distinguish between what is the substance of the document, what is the document doing, and what are the, and I won't say it's just boilerplate, but the, yes.
As I understand it, he's saying you can't really hang on to a pleading that talks about Annex 5 as amended from time to time if what you now are offering is something completely different.
But that, my lord, with respect, is the key question. My lord puts it on the basis what we're offering is something completely different. And in my submission, a compare-right is not the way to establish that.
But it talks about a draft licence as provided, as amended from time to time.
Yes. Well, that's right, my lord. And of course...
But in any event, you say all of this is completely irrelevant because the judge's decision was not based on the terms of the interim licence that was being offered. His decision was a matter of pure principle. You couldn't do it no matter what the terms were.
And I follow that. But just coming back to the pleading, suppose that this court gives you permission to amend to introduce 52G.1.
Yes.
Well, then one says, well, where is the Annex 5, which incorporates these amendments? And there isn't one.
Well, my lord, look, I shall run through my points as to why we say this procedural objection is unfounded. The fallback, of course, which we've explained in the supplementary skeleton, is if I do need, very modestly, to adjust that paragraph, so as simply to say the offer made in December, then I ask for that permission, because where on earth is the prejudice in circumstances where that offer simply reflects what Nokia was itself prepared to offer, and in circumstances in which in a month one would expect, if there were really any substance in this objection, for it to be said, well, we've now been deprived of the ability to advance some knockout point against your case that we would have been advancing. Nothing of the sort has been identified, nor conceivably could it, given that this is an attempt to be sensible and to move closer to what Nokia has itself proposed as a way of taking issues off the table. So if it is necessary for that small adjustment to be made, then I ask for that permission. But let me come back very briefly to the reasons why we say that this objection really is unfounded. The first was that we submit the draft pleading doesn't require amendment. That takes us into the point about as amended from time to time. You've heard my points on that. What really matters here is the substance, and the substance is simply that we have narrowed down the scope of the offer in terms of the patents that are covered, so as to align more closely with what Nokia were proposing, and adjusted potentially the consideration. And that is the substance of the thing. Of course, by saying that we will move to the terms Nokia proposed, that then entails a position where inevitably, because people's offers are drafted on different templates, if you were to do a compa-write, probably you would end up with lots of red text, but that doesn't fairly reflect the substance of the thing, which is that we are simply saying that the interim license should be narrower than previously and have moved the consideration closer to what Nokia is suggesting. Certainly the grounds of appeal require no adjustment, and that is because, and this is the second big point that we make, and this is the point that my Lord Justice Arnold has already referred to, the judge's reasons for refusing permission did not turn on the scope of the offer at all. The judge's concern was one of principle as to whether interim licence relief could be available in law at all.
Yep.
Thirdly, we say that this further offer was made in a sensible attempt to reduce the scope of the issues, and there's nothing unfair or prejudicial to Nokia. Indeed, one might say that what's really remarkable about all of this is that despite having had a month to reflect, Nokia is apparently not prepared to enter into an interim license, even on the very terms which they have themselves proposed as RAND. And as we observe in paragraph 13 of our supplementary skeleton, that can only be because Nokia wishes to avoid the court testing whether that offer is RAND and determining RAND terms altogether by forcing Amazon to its knees before the trial can ever take place. And then the fourth point that we cover in the skeleton is a point of detail which we address, and I don't need to develop. And then the fifth point is, it is said by Nokia, well, your case at trial will be that this offer is not RAND. So how can the court determine the terms on an interim basis? But of course, that ignores the whole concept of an interim license. The very essence of an interim license is that it is adjustable. The court is doing its best on an interim basis, and that will often involve, as in Panasonic and Xiaomi, splitting the difference between the parties. And unless they make concessions in due course, each party will go into trial, usually saying that the interim license was too high or too low, respectively, and the court works out who is right. If the court could only settle interim licenses on terms that an implementer itself accepts would be RAND in a final license, then that would defeat the whole concept of an interim license. So we do say there's really no legitimate procedural objection here. If there is, to the extent that my lords have identified in relation to the draft.
Go back to explain that to me. Why? I mean, in very simplistic terms, the implementer offers as little as possible, and the owner of the patent asks for as much as possible. So why would it be wrong as a matter of principle for an interim license to be on the lowest number on the basis it could be adjusted up?
My lord, it's entirely, of course, for the court to determine where it wants to split the difference.
Why would it defeat?
Sorry.
I thought you said it would defeat the purpose. Yeah. Sorry. You said.
Sorry, my lord. I think perhaps I wasn't clear about the point I was addressing. The point I was addressing was, in Nokia in their skeleton, suggest that they have an easy answer to the interim license that we seek based on our revised offer, because we intend to say at trial that the offer which we are prepared to enter into on an interim basis is not RAND. They say, well, how can that be? How can the court declare an interim license on terms that you, the implementer, intend to say in due course are not RAND.
That's, what you said was if the court could only settle interim licenses on terms that an implementer itself accepts would be RAND in a final license, then that would defeat the whole concept of an interim license.
Oh, I'm sorry, my lord, I should have said that terms that an implementer or the SEP owner, because the suggestion from my learned friend is effectively that unless the interim license corresponds to terms that one or other party will be going into trial saying are RAND, then the court can't determine those terms on an interim basis. And that is inherently contrary to the whole idea of an interim license as explained in Panasonic and Xiaomi. In Panasonic and Xiaomi, the court split the difference.
Yeah. But it could be a possible term of an interim license for the court to say, okay, the implementer accepts that these terms would be RAND for a final license, and those will be the terms of the interim license, and then they may have to be adjusted up.
Yes.
Why does that defeat the purpose of the interim license, which I thought was what your submission was, and that's what I didn't follow?
Because the court can decide to do that. Of course it can. What my learned friend's submission is a rather different one.
Okay.
Is the court can only do that if the terms correspond with terms that one or other party accept to be final FRAND, as it were. It attempts to hold against me the fact that Amazon is prepared, being sensible and wanting to progress this dispute, to enter into terms on an interim basis that are higher than it will be saying at a RAND trial are actually RAND. My own friend tries to say that in those circumstances, Amazon is stuck. It can only ever contend for an interim license on terms which correspond to the case which it will be advancing at the final RAND trial.
And your simple point is that would be a massive disincentive to compromise.
Well, quite, my lord. Indeed, it would create inherently, and perhaps this is deliberate, the very situation that the court says in Panasonic and Xiaomi is not to be created in an interim license case, i.e. that you have two fully fledged RAND trials, because if no one can contend for terms which are more favourable to the other party than they intend to contend are RAND at the final trial, you will end up with an interim license trial which is the same as the RAND trial.
And then you won't have an interim license trial.
Yes. Yeah. And no doubt that suits Nokia's purposes in all of this to bring that situation about. But that is not, we say, consistent with what Panasonic and Xiaomi is getting at. My lord, if you're against me on all of those points, and I do require a permission of some kind to advance the amendment application appeal based on the revised offer, then I seek that permission. As I say, it's not clear what document. Certainly the grounds of appeal require no adjustment.
Well, it's amending 52G.
It would be amending 52G.
To refer to the letter of the 12th December. It's a very straightforward adjustment.
I'm just trying to think through how it would work. So on this thesis, if we tie you for the moment to 52G.1 as it stands, you're appealing the judge's rejection of 52G.1.
Yes.
You say, well, he went wrong in principle. He didn't have the benefit of the Court of Appeal in Panasonic. Doesn't matter about the detail of the terms. He went wrong in principle.
Yes.
Were this court to accept that position, then on 52G.1 as it stands, we would presumably have to determine whether we could ourselves decide what should now be done, in the sense that the judge's decision would have been shown to be flawed, but it wouldn't necessarily follow that you should have the permission to amend. We would have to revisit his decision, would we not?
Yes, my lord is right on that. And at that point, it is then the matter for the discretion of the court.
Actually, in undertaking that new exercise, if needs be, the court can think about a slightly different formulation of 52G.1.
Yes, that is how it would pan out. And indeed, from recollection, there is an authority in the bundle. Yes, Limbu and Dyson is in the last tab of the bundle of authorities. And there is a passage in that authority explaining the point. But I shall come back to that, I think, in the context of my points on amendment. But I think the point of principle is establish an error, in which case the permission to amend falls. Sorry, the refusal of the permission to amend falls. Then the question for the court is, do we grant permission to amend? And if at that point the court is only prepared to grant permission to amend on the footing that 52G or is amended so as to reflect the updated offer, then so be it. And ultimately there is no conceivable prejudice to Nokia in proceeding in that way. And there would indeed be enormous prejudice to Amazon in proceeding in the alternative way, of course, which would, my learned friend invites this court at that point simply to allow the appeal, presumably, and do nothing about amendment, and then force me to make a further amendment application in the High Court, adjusting a single paragraph, which will just create weeks and months of delay. My lords, that brings me to the third topic, which was the test for permission to amend a pleading. We deal with that at paragraphs 2 and 63 of our main skeleton. It was dealt with in the CNM Estates case fairly recently. It's in Authorities Volume 1 at tab 10. This was a case about whether the lower court had erred in refusing permission for the claimant company to amend its pleading. And just quickly picking up Mr. Justice Mayall's, sorry, my apologies, Lord Justice Mayall's, of course, at paragraphs 48 onwards, page 204. And 48 makes the point that it's real prospect of success and one doesn't give permission for fanciful pleadings. And 49 makes the point that unless we're talking about a very late amendment, which clearly we're not here, beyond that it's not appropriate to consider the strength or weakness of the claim as a factor relevant to the exercise of discretion. That's a point that was picked up by the Master of the Rolls and Lord Justice Newey at paragraphs 77 and 79. At page 210. I shan't read it all out, but they cite with approval Judge Eyre, QC, and next to G, they say at the stage of considering a proposed amendment, that test imposes a comparatively low burden, and the question is whether it's clear that the new claim or defence has no prospect of success. The court is not to engage in a mini-trial, etc. And in paragraph 79, they find that the judge was mistaken to attach significance to whether the proposed claim could be considered weak, having passed the threshold of a real prospect of success. And one synonymous expression for no real prospect of success, as determined in Begum and Moran, which we cite in our skeleton, is whether the claim is bound to fail. That brings me to my fourth topic, which is the judge's reasoning and Amazon's appeal against it. The reasoning is in the core bundle, volume 2, at tab 35. And we will see at page 220 the reasoning starts at paragraph 79. Having summarised the pleading, the judge says, in my judgment, there is no sufficiently arguable case that the premise, i.e. the Swiss law principles identified, so that's good faith and the such like, leads to the conclusion that Nokia is obliged to enter into an interim license. He then identifies what the principles of Swiss law identified were. And in 81, the judge says, assuming that the RAND commitment gives rise to an enforceable obligation to enter into negotiations for a RAND license in good faith, I do not see how that leads to the conclusion that Nokia, in addition to entering into good faith negotiations to enter a license on RAND terms, which is to have retrospective as well as prospective effect, must agree to enter into a license at an early stage, whether that is or is not characterised as a second license, covering at least part of the same period that will be covered by the final license, pending resolution of the terms of the final license. And those paragraphs 79 to 81 are really the core of the reasoning in relation to good faith. The judge couldn't see how one could get from a duty of good faith to an obligation to enter into an interim license. We then have at 82 to 84 consideration of the Swiss law principle that obliges Nokia to refrain from seeking to enjoin Amazon in the meantime. And the judge says, well, at 83, you could... The judge says at paragraph 83 that one could... Sorry, 84, that it could be asserted independently. But that part of the reasoning is not essential for the purposes of my appeal anyway. Our case, based on good faith, is quite sufficient to establish the arguability. And the reason that I make that point is that Panasonic and Xiaomi is largely based on good faith. So the obligation to refrain from enjoining elsewhere in the meantime is icing on the cake, as it were. We then have 85 onwards, which is a similar question was recently determined by Mr. Justice Leach. And then the judge refers to the High Court judgment in Panasonic and Xiaomi, which had, of course, rejected the application. It is not completely clear the extent to which the judge was or wasn't influenced by the High Court decision. In paragraph 87, the judge makes the point that it's not binding, it's a different regime, etc. There are then attempts to distinguish, which were rejected at paragraphs 88 to 89. But it does appear that the High Court decision was influential, at least to the extent identified in paragraph 87. At any rate, those paragraphs, in a sense, have ceased to matter since the Court of Appeal's decision overturning the High Court. And then at paragraph 90, and this is the point that I was discussing with my Lord Justice Snowden earlier, the judge says that he would have been inclined to refuse on case management grounds to give directions for the resolution of the terms of an interim license. Now, the first point there is, of course, that the judge wasn't saying he would have been inclined to refuse permission to amend on that basis. And he has indeed clarified in his permission to appeal judgment that that is the right understanding of that paragraph. One sees that at page 240 in this bundle. So far as where he says in paragraph 25, so far as the case management difficulties identified are concerned, those were not part of my reasoning on this point of law. And if one goes back to paragraph 90 of the main judgment, what the judge was saying was, not actually something in connection with permission to amend at all, but rather he wouldn't have given directions for the resolution of the terms of the interim licence. And the reason for that is essentially the point that I made to my Lord Justice Snowden when we were debating the point, i.e. one would need, as the judge puts it, 2 RAND trials at the end of paragraph 90. And that is a point that the Court of Appeal in Panasonic and Xiaomi expressly rejects, as we shall see. So that then brings me, my Lord, I've mentioned it many times, to the decision of the Court of Appeal in Panasonic and Xiaomi, which is in the authorities bundle at volume 2, tab 14. This was a successful appeal by Xiaomi against the decision of Mr. Justice Leach, by which he had refused Xiaomi's application for interim license declarations in a FRAND case. In a sense, I rely on the whole of my Lord Justice Arnold's decision and judgment, but I highlight in particular the following paragraphs. Paragraph 7, and I'm afraid on grounds of time, I'm not going to read out these paragraphs and just draw attention to them. Paragraph 7 about the need for a well-functioning dispute resolution mechanism. Paragraph 11 about the developments whereby the courts of an increasing number of countries have held that they have jurisdiction to determine global terms. Then paragraph 21 at page 117, an important point about FRAND as a process. That the FRAND obligation extends to the process by which, this is the fourth line, the parties negotiate for a license. What this means is the SEP holder is required to behave consistently with its obligation to grant a license on FRAND terms. Consequence being, 4 lines up from the end, that the SEP holder should not behave in a manner which promotes hold up, etc. I can then turn to paragraph 45, which, having referred to the German proceedings in that case, observed that it can be seen from this that a prodigious amount of time, effort and money is being expended by the parties, etc., on the German proceedings. A key question on this appeal is what the point of this is, when it is certain that in the relatively near future the parties will enter into a global licence on the terms determined by the English Patents Court to be FRAND. And that was the question that the court asked. We can see from 48 and 49 reference to the French law duty of good faith. I've shown the court where we plead in the Part 20 claim the Swiss law duty of good faith. There is then reference in paragraph 50 to the German procedure for dealing with FRAND claims. The key point being that in paragraph 51, which is that it does not involve determining what terms are in fact FRAND. That's the second and third lines of that paragraph. So it's simply not the same exercise that this court will be engaged in. At paragraph 57, at page 126, we can see that the terms proposed by Xiaomi for the interim license also evolved. And that's the point about the parties' proposals inevitably evolving and converging. At 58, we can see that Panasonic's position was essentially that of Nokia here. It said that it was entitled to enforce its SEPs in any court of competent jurisdiction unless and until Xiaomi actually takes a license. We can then move forward, my lords, to ground 2 on good faith, which is at page 131. And at 74, we can see that there were 2 submissions which were labelled Submission A and Submission B. Submission A was about good faith. And as I say, I shan't read that out, but there's the good faith-based submission. And we can see from 75 that Xiaomi focused their arguments on the good faith point. And the court turned to deal with this at paragraph 78 on page 132. Xiaomi contend that the judge reached the wrong conclusion on this issue. I agree with this. And then at 79, there is the important point that SEPs differ from normal patents. And then at 80, the point I referred to earlier, which is even more important, namely that the implementer is entitled to a license from the first day it implements the standard, provided it is willing to take a license on FRAND terms. Furthermore, the implementer is entitled to a license which is continuous and not subject to interruption by injunctions obtained by the SEP holder. Against the background provided by this preliminary points, the key factor in the present case is that, as explained above, it is certain that the parties will enter into a global license of Panasonic's SEP portfolio on the terms determined to be FRAND by the Patents Court in the relatively near future. Now, pausing there, Nokia has precisely the same certainty here. It has an undertaking from Amazon to enter into a license on terms which are FRAND, settled by the only court in any of the proceedings in the world which will actually be undertaking that exercise. At paragraph 82, my Lord returns to the question I posed in paragraph 45 above. What is the point of Panasonic pursuing the German proceedings with all their attendant effort and expense in the circumstances? As the judge noted at 95, Panasonic is candid that its objective is to obtain injunctions in order to achieve a negotiated settlement with Xiaomi rather than await the determination of the Patents Court. Now, Nokia's evidence is likewise clear that it wishes to avoid an interim license precisely because it wants to achieve a negotiated settlement before the RAND trial. That's MOS 4, paragraph 99 in the supplemental bundle, tab 7 at page 193. What purpose is served by this, given that Panasonic is assured of getting FRAND terms anyway as a result of the Patents Court decision, and two, nothing in the English proceedings prevents the parties from negotiating an earlier settlement of their dispute? We make precisely the same points in this case, and I shan't read the whole of that paragraph, but naturally I rely on it. 84 says Xiaomi have offered to take an interim license with the payment of royalties to Panasonic pending the determination of the Patents Court. Any rational SEP holder in the position of Panasonic would want to be paid sooner rather than later. Again, we make precisely the same points as are made in this paragraph. We then see in 86, the next question is whether in these circumstances Panasonic is acting in good faith in negotiating a license with Xiaomi on FRAND terms as required by clause 6.1 of the ETSI-IPR policy. As the judge recognised, the fact that Panasonic may believe that it's entitled to adopt this course does not compel the conclusion that upon an objective assessment, Panasonic is acting in good faith. And then there's reference to the fact that Panasonic's conduct is indefensible, that FRAND is a process, and that Panasonic is not complying with its obligation to negotiate a license with Xiaomi in good faith and thereby avoid hold-up, but aiming to coerce Xiaomi into accepting terms more favourable to Panasonic than the Patents Court would determine to be FRAND. And we submit, of course, that there is a perfectly arguable case here, a pleadable case, that precisely the same applies in relation to Nokia. The court deals with useful purpose at paragraphs 88 onwards. And we can see that what happened in 89 was that Panasonic said that even if the court made a declaration, it would just ignore it. A bit like the argument that's being advanced by Nokia, that because they have themselves at the moment, despite being the claimant in the patent infringement proceedings, and despite it having been determined that it is arguable that the RAND license would encompass the very patents in suit, Nokia have nevertheless declined so far to give an undertaking to offer the license that the English court will set. So very similar to the position being adopted by Panasonic here. And the court says, in my judgment, paragraph 90, making the declaration sought by Xiaomi would serve a useful purpose in forcing Panasonic to reconsider its position. It would not force Panasonic to change its mind, but in my judgment, there is a realistic prospect that it will do so. And the reasons are further explained in that paragraph on which I rely. Of course, there is the additional point in this case that we say that because it's the Swiss law obligation, specific performance is available. And so that would be a further point meeting Nokia's apparent refusal to abide by any determination of the English court. But I don't, as I say, need that because this same reasoning on useful purpose would apply in relation to declaratory relief, which is quite sufficient for these purposes. Specific performance is an arguable case on top of that. I think at that point I can go forward to the reasoning on comity. At paragraph 95, we can see that the judge had held that the only useful purpose of making declarations sought would be to influence the outcome of the German proceedings, and that was not a legitimate purpose because it would be contrary to comity. But the premise was rejected for the reasons given above, which of course are then developed. Furthermore, if the declarations do induce Panasonic to reconsider its position and to grant Xiaomi an interim license, that would, as Xiaomi submit, promote comity because it would relieve the German courts and the UPC of a great deal of burdensome and wasteful litigation. If, on the other hand, Panasonic decides to ignore the declarations and to pursue the German proceedings, it will be entirely for the German national courts to make their own assessment of their conduct. And then at 99, the court deals with how to determine the terms of an interim license. And makes the point that it's not simply a binary choice between the parties' proposals. The court can decide to determine a set of terms which are neither party's proposal. And last sentence of that paragraph, contrary to the view taken by the judge, this does not involve determining what terms for a final license would be frowned. That meets the point that the judge made at paragraph 90 about 2 RAND trials. That is not what is concerned here. The court is concerned with a different, much more modest question of what terms are appropriate to hold the ring. And the court determines that at paragraph 100. Essentially, although I'm sure I'm doing a disservice to the reason, but essentially splitting the difference between the parties. My lords, we say quite simply, the logic of Panasonic and Xiaomi applies clearly, or at the very least arguably, which is all that matters here, to a situation where English proceedings are the only proceedings which will be determining RAND terms, where the implementer has undertaken to take whatever those terms may be, but where the SEP owner is carrying on seeking and enforcing injunctions, the purpose of which can only be to prevent the implementer from being able to make it through to a RAND determination on the merits. The court doesn't need to conclude that is actually why Nokia is behaving in the way it is, only that we have a real prospect of success of establishing that. And my lords, with the benefit of that analysis in Panasonic and Xiaomi, one can in a sense return to the judge's reasoning, which is in Core 2, tab 35. And developed, as the court will have seen from paragraph 15 of our skeleton, we make 5 points, but I can develop them by reference to this reasoning. Paragraphs 79 to 81, which deal with good faith, are met entirely by the reasoning of the court in Panasonic and Xiaomi, and that explains exactly how the premise of a duty to negotiate and perform in good faith can lead to it being appropriate to grant interim license relief. Paragraphs 83 to 84 are, as I say, about an ancillary principle about not seeking injunctive relief abroad, but which doesn't matter in light of the reasoning on good faith. 85 to 89 deal with the judgment of Mr. Justice Leach, which has, of course, been superseded. And paragraph 90, it proceeds on the mistaken premise that an interim licence determination would require two RAND trials. And in those circumstances, all of the points that we make in paragraph 15 in the summary in our skeleton argument are amply made out. And the most important being, by some margin, being that Panasonic and Xiaomi explains how one gets from good faith to a duty to offer an interim license. Now, what is Nokia's response? Well, they develop 5 points which we address in our supplementary skeleton at 25 to 29. Paragraphs 25 to 29. The first point they make is to say that Panasonic and Xiaomi was a case about the ETSI-FRAND obligation under French law, whereas this is a case about Swiss law and the ITU RAND obligation. But as the court has seen, Amazon has pleaded that a duty of good faith arises under Swiss law just as under French law. That's that's in the Part 20 claim that I showed you. But I should also show you the RAND statement of case, which gives further details on this. Core 2, tab 30, page 24 onwards. Paragraph 14, pending expert evidence, page 24, Amazon will rely on the following principles of Swiss law, which will be the subject of expert evidence in due course. C is, just over the page, that there is a pre-contractual obligation for parties to negotiate in good faith based on the principle of culpa in contrahendo. But it's not just pre-contractual obligations. M, on page 27, pleads that Article 2 of the Swiss Civil Code provides that every person must act in good faith in the exercise of his or her rights and in the performance of his or her obligations. And then at paragraph 15 on page 28, it is observed, third line, it is common ground and admitted by Nokia that the Part 20 defendants have entered into a binding Swiss law contract with the ITUT to enter into good faith negotiations in respect of a worldwide licence to claims essential. B, offer a RAND licence, and C, enter into on acceptance. And then the following paragraphs plead that the approach under ETSI-FRAND should be applied by analogy. So we say the fact that this is a Swiss law case certainly is no knockout blow in circumstances where we have a pleaded case that there are very similar, if not identical, duties of good faith under Swiss law as there were under French law. That's the first point they make. The second point that Nokia makes by way of response is to attempt to distinguish Panasonic and Xiaomi on its facts. We address those contentions in paragraph 26 of our supplementary skeleton. I'm afraid there simply isn't time to run through all of them. But picking out the most important, they say that this is a case where RAND arises as part of a defence to proceedings on a non-essential patent, rather than a case where it is a defence to proceedings on a standard essential patent. Now, there are two reasons that's wrong. First of all, there really is no basis for suggesting that that ought to make a difference to the applicability of the principles in Panasonic and Xiaomi, which are concerned with the RAND obligation, which has been squarely invoked, as I showed the court, in Amazon's counterclaim, and which the judge has determined affords an arguable defence to an injunction claim based on a non-essential patent in the circumstances of this case, in just the same way as in a SEP case, it may afford a defence to injunctive relief. But what is more, as I showed the court, Amazon is itself counterclaiming for RAND declarations in relation to two of Nokia's UK SEPs. So there are two UK SEPs squarely in issue in this case. So those are not a basis for suggesting that the principles in Panasonic and Xiaomi are unarguably inapplicable here, which is what my learned friend's case would need to be. A further point which Nokia makes, which I've addressed to an extent, is to say that they have not themselves undertaken to offer the license, which is RAND, but in my submission, it cannot be right that simply by unilaterally refusing to engage with the court's jurisdiction, a SEP owner is able to defeat what would otherwise be the useful purpose of declaratory relief. And in that regard, I rely on everything that was said in Panasonic and Xiaomi about the position adopted by Panasonic. What is more, it's actually common ground, because Nokia accepts it in paragraph 45 of its skeleton, that it is not a prerequisite to the applicability of Panasonic and Xiaomi that the SEP owner should itself have given an undertaking to the court. So ultimately, in our submission, any points of difference in the underlying facts of Panasonic and Xiaomi are not points which affect the arguable applicability of the principles identified in that decision. The third point which Nokia makes is to say that because the interim license offer is now limited to SEPs, it can only have the purpose of influencing foreign proceedings rather than having any utility in managing the UK proceedings. And that is, for all the reasons I've already gone through, clearly wrong. Nokia's SEPs and the RAND rate for those SEPs are squarely in issue here in the UK. And it is with a view to promoting the efficient resolution of that RAND dispute here in the UK that Amazon seeks relief. As this court observed in Panasonic and Xiaomi, if the effect of interim license relief is to relieve other tribunals of wasteful infringement litigation, then that promotes comity rather than harming it. The fourth point Nokia makes is to say that it disagrees with Amazon's case on Swiss law, but that just demonstrates that there is a triable issue here. And the fifth point they make is to rely on the German decision, to which I shall come in a moment. But I submit that where we've got to is proceeding on the basis of the draft pleading and the materials which were before the judge. The position following Panasonic and Xiaomi is clear. Amazon's case is not bound to fail, and we should be permitted to plead it. That then brings me to the final of my 5 topics, which was Nokia's additional points, including the foreign decisions. Now, perhaps recognising the force of the submission I've been advancing, that Panasonic and Xiaomi clearly does change the picture, Nokia seeks in its skeleton argument to rely upon 2 additional matters which I can address in turn. The first is the foreign decisions. The first additional matter that Nokia seeks to rely on is 2 decisions in foreign proceedings, one from the Munich District Court and one from an administrative law judge in the ITC proceedings. We address those decisions at paragraph 7 of our supplementary skeleton argument, and we make a series of points. The first is that those are not decisions which were before the judge, and there has been no application to rely upon them as additional evidence. Is
that required?
Yes, my lord, because they are...
Surely a judgment of a court speaks for itself. It doesn't require evidence. It may require evidence to contextualise it and to enable conclusions to be drawn, but the judgment in and of itself proves itself, surely.
Well, my lord, I was about to come, in fact, to the point about contextualisation, because my point on this is it's not an arid procedural objection. It is a point of substance, because the difficulty with the fact that these decisions were not before the judge is that this court, as a result, has no foreign law evidence at all contextualising or explaining where these decisions might fit into
That's a slightly different point.
their respective legal
I think
systems.
that's a slightly different point that my lord's been putting to you. I mean, for example, in this court, regularly you have authorities cited, for example, from Hong Kong.
Yes.
Nobody suggests that you have to make an application to admit them as evidence just because they come from a foreign court. I think my lord is putting to you that you're just putting in front of us a decision of a German court.
Yeah, I appreciate that, my lord, and it may be that there's a difference depending on whether one is relying on a foreign decision as an authority or as a piece of evidence. But in a sense, I don't think I need to cross swords with my lords on this, because I was not intending to run it just as a procedural point. What's much more important in my submission is you can only understand these foreign decisions if they're properly placed in their context. Take an example of the administrative law judge decision from within the structure of the ITC. Now Mr. Moody Stewart has already made the point to you in my submission correctly and fairly that in fact that decision is very difficult to follow at all because of the redactions. But even leaving that aside, one needs to understand what the significance or otherwise of that decision within the ITC system actually is. It is not, and I'm having to make submissions here as they are advanced in the skeleton argument because there isn't any evidence from anybody on this, but the administrative law judge's decision is not a decision of the ITC. The ITC is perfectly free to depart, if it wants, from what the administrative law judge decides, and indeed Amazon will be making its submissions in that regard.
Just going off briefly on a tangent, trying to think where all this would fit in. As you say, you can perfectly well cite a Hong Kong decision or a decision from elsewhere in the world in support of a legal proposition, but that's not what we're concerned with. We're concerned with the application of law to facts.
Yes.
Now, Mr. Moody Stewart will be explaining his position, but presumably there is the idea that a decision of a foreign court, because it relates to a dispute between the same parties, should be given significance in relation to findings of fact. Now, it's undoubtedly the case that foreign judgments can give rise to issue estoppels. But I don't know if that's...
And my lord, that in fact is the second point that we make on this. So in paragraph 7.4 of the supplementary skeleton, we make precisely the point that my lord puts to me, which is that there's no evidence, and indeed our understanding is that it is simply not the case, that either of these decisions is final, even within their foreign legal systems.
Well, before we get into that, as I understand it, the way this would go is as follows. If they want to rely upon it as an issue estoppel, they have to plead it. So all this sort of is begging massive numbers of questions, because they only need to plead issue estoppel if you get permission to amend in the first place.
Yes.
So the argument seems to be that we can decide to the summary judgment standard that you shouldn't have permission to make your amendment because it is inevitable, A, that they will plead issue estoppel, B, that they will establish issue estoppel, and C, that the issue estoppel will preclude your argument.
Well, indeed, my lord, yes.
It's like quite a tall order.
It is, and that actually brings me, I think, to the third problem with all of this. My lord, I absolutely accept everything that my lord has just fallen from my lord. But even if one got over all of those hurdles, one would then need to be satisfied that the issue which is determined in the foreign proceedings is actually the same issue which will arise on the interim licence application, and it is simply not, for the reasons that we have explained in our supplementary skeleton in some detail at paragraph 7.3.1 to 7.3.2 in relation to the German decision. Now, I already showed the court paragraph 51 of Panasonic and Xiaomi, which makes the specific point that the German approach does not involve determining which terms are in fact frowned. But as we explain in those paragraphs, the German decision is not one which determines round terms. It's a competition law-based examination of whether the parties' negotiating stances were not obviously unfrowned. And that is, of course, the same standard that the German courts would have been applying in Panasonic and Xiaomi. And the consequence of my learned friend's submission, were it correct, would be that if Panasonic had already obtained an injunction against Xiaomi in Germany based on that standard, then its position would somehow have been better than the fact that it was just applying for such an injunction in Germany. And that really is not correct in our submission. I've given you the reference to the detailed consideration of the German approach in Lenovo and Digital, which is at Authorities 2 at tab 12 at page 7. Paragraph 20, Mr. Justice Richards explains that in Germany, by contrast with the position in England and Wales, the Fran defence is not based on the interpretation and application of Clause 6.1. Rather, it is based on Article 102 of the Treaty Functioning of the European Union. So it's a competition law argument. And we can see from paragraph 22 at page 8 in subparagraph 2 that the test that is applied to determine whether a SEP holder is willing is assessed initially by looking at the offer of a licence actually made by the SEP holder. If the offer is not devoid of all reason, also sometimes summarised as obviously non-fran, the SEP holder is likely to overcome this initial hurdle for these purposes. But assuming they overcome that hurdle, as we can see from 4, attention shifts to whether the implementer is willing. And then paragraph 6 of that, if the implementer is assessed as being unwilling, then it's likely the SEP holder will obtain an injunction. In that case, the injunction is likely to be granted without any consideration of what the Fran terms actually are. And we can see from 9 over the page that there has to date been no decision of the German courts as part of infringement proceedings relating to SEPs in which the terms of a global Fran licence or the royalty that should be paid for such a licence have actually been determined. So it's never happened, and the approach does not require it. And if one wants to understand the difference between an abusive offer in negotiations and a Fran price, that is an issue which Mr. Justice Burse, as he then was, considered in Unwired Planet, which is in Authorities 1 at tab 2. And if one goes to paragraph 757 on page 18 of this bundle, it was common ground between the economists, but I hold as a matter of law that the boundary of what is and is not a Fran rate is different from the boundary of what is and is not an unfair price, contrary to Article 102. So that's the competition law standard. If the rate imposes is Fran, then it cannot be abusive, but a rate can be higher than the Fran rate without being abusive too. Paragraph 765. In the context of SEPs and Fran, as long as the recipient of the offer can see it's made in that context, then it seems to me that only an offer which is so far above FRAND as to disrupt or prejudice the negotiations themselves in the manner described by Professor Nevin above will fall foul of Article 102A, it's a high standard to reach, etc. The judge then compares in 767 onwards his FRAND rates with the offers and determines, for instance, as one can see from 773, that a rate that was 3 times the FRAND benchmark rate was still not abusive because it wouldn't prejudice the negotiations, likewise 774. And one got to the boundary at 778 where if an offer had been 25 times the FRAND rate, that might well be prejudicial, but that taking that particular offer in isolation would not be appropriate. And 784 at page 22 rejects the competition law case. The finding is not that the imposition of a rate 3, 5 or 10 times FRAND would be acceptable, far from it. The flaw is these offers were obviously made as a step in negotiation, did not prejudice or disrupt it. And the same principle of law is confirmed at 806, subparagraph 3 at page 23. The boundaries of FRAND and competition law are not the same. And one can see that standard of whether an offer is a satisfactory basis for negotiation being applied in the German decision, which is in the supplemental bundle at tab 17. Now, this judgment was the result of a one-day hearing, which had dealt with all of the technical issues in addition to the RAND defence. At page 304, we will see from paragraph 110 that the reason that Amazon's defence of compulsory licensing failed was due to a lack of willingness on the part of the defendants to obtain a licence. Now, I'll come to the reasons why that was in a moment. But we can see from 114 over the page that having notified the implementer, further obligations of the dominant patent proprietor arise if and only if the user of the protected technical teaching expresses his intention to conclude a license on FRAND terms. So if the implementer is assessed not to be willing, then the SEP owner is simply relieved of any further obligations. And when does that happen? Well, we see the standard at paragraph 120 on page 307. The license seeker is only completely released from the duties to react and therefore to simultaneously mention all obvious objections if an offer is non-FRAND to such an extent that when objectively assessed it appears not to be meant seriously and thus as a refusal to conclude a license agreement on FRAND terms. That's the standard that Mr. Justice Burse was describing in Unwired Platens. We see at page 312 at paragraph 139 that applying the principles set out, Amazon cannot claim exemption under antitrust law. Nokia's offers are assessed at 146. Plaintiffs submitted various offers which, in the opinion of the board, were each suitable as a whole to initiate the discussion regarding an appropriate FRAND licence as required by the case law. At 147, they say because it's a negotiation process, the FRAND licence rate is not a fact that can be established by expert evidence. We can further see that same standard being applied at 165 at page 316. That the offer was, as per the third line, within the permissible price range for commencing negotiations with the defendant. And then, importantly, we see why, at 169, Amazon was assessed as lacking the necessary willingness to obtain a license. And the reason is, at 171, that the Chamber is convinced that the defendant's refusal to enter into a licence agreement for the terminals it distributes on FRAND terms is motivated by its broader interest in ensuring that the streaming service, Amazon Prime, is also licensed. And that criticism is made again at 173. Now that feature of Amazon's position is the very thing that Mr. Justice Zaccaroli determined Amazon was arguably entitled to insist upon in terms of the scope of the license. So the reason why the German court ultimately enjoined Amazon is that it didn't think that Amazon should have been asking for a streaming license as well, when that's the very thing that Mr. Justice Zaccaroli has found was arguable and should go to trial in terms of Amazon's entitlement. I can't go through it all, but I think my learned friend will rely on paragraph 192 at page 322, which says, against this background, it's not decisive whether plaintiff's offer complies with FRAND terms, that this is nevertheless the case has already been explained in detail above. But my lords, when one looks at this decision as a whole, one can see immediately that what the court means by that is it meets the test of not obviously unfrand. Is it an appropriate offer to be making in a negotiation? It is certainly not a RAND determination. And the truth is, the significance of this German decision...
We also need to take into account what's said at 182, which is they reiterate their established practice that the patent parser may determine which agreements should be submitted to demonstrate the reasonableness of the requested license fee. Yes. In other words, the patentee is allowed to select which license agreements are seen by the court in order to determine what's comparable. So the patentee, according to this practice, is allowed to withhold any comparable licenses that might favour the implementer.
Yeah, my lord, yes. And I was, in fact, that was one of the paragraphs I had in my list to take the court to, and I'm most grateful.
At any rate, supposing that this judgment is capable of giving rise to an issue of estoppel, you say there is no determination of an issue which matters for our purposes.
Quite right. And for good measure, it's also under appeal. The significance of this decision really is actually not its reasoning or any argument about issue estoppel. The significance is instead that Nokia has proceeded to obtain and enforce an injunction in Germany in relation to an SEP in respect of which Amazon has already undertaken to take a license on RAM terms in the only set of proceedings anywhere in the world that will actually be determining those terms. That, in my submission, exacerbates the lack of good faith rather than makes the position any better. And then finally, in relation to the ITC, the simple point, and there isn't time to go through the reason, but the simple point is that it is not a final decision of the ITC at all. It's just a step within the process with which the ITC may, and not uncommonly does, disagree. As I understand it, although of course we don't have any evidence on this, but it's a bit like an Advocate General's opinion or something like that. In any event, as Mr. Moody Stewart rightly observes, it's been redacted so extensively that it is impossible to make any sense of what is there anyway, as you will see in due course. So, my lords, we say that these foreign decisions really do not begin to establish that there is no arguable case for an interim license here, that Amazon has no arguable case that Nokia is in breach of its duty of good faith or is seeking to obtain super-FRAND rates. The other additional point that Nokia makes is its case management submissions. I think I've already addressed that. It's all based on the premise that we would be having 2 RAND trials. Clearly, we are not going to be having 2 RAND trials. the points are addressed in detail in paragraphs 17 to 22 of our supplementary skeleton, and I rely on those submissions.
And just showing I don't have those clearly in mind, in circumstances where we suppose that you were allowed to amend and then you have a hearing as to what should happen on your amendment, how long would you think that hearing would last?
We have suggested 2 to 3 days conservatively. The reality is that given the updated offer, it's difficult to see what disagreement there will in fact be between the parties as to the appropriate terms, unless Nokia intends to say that its own offer is somehow inappropriate as an interim basis to hold the ring pending the RAND trial. Of course, there will be issues about Swiss law. My learned friend will want to make his arguments, and they're perfectly capable of being dealt with. There may be an argument, my learned friend has indicated that he may wish to take his point that encoding claims are not in fact standardised claims and therefore within the scope of the obligation. But again, there's no reason why that's not capable of being decided in 2 to 3 days. And in any event, if the court determines that the appropriate scope of the licence is just the decoding claims, then so be it. The court's perfectly able to decide that that's the only interim licence it's in a position to settle.
I'm not sure that really we need to get into this degree of detail, but you say that you anticipate there could be a Swiss law argument. As soon as one talks about arguments about foreign law, 2 to 3 day estimates seem a bit more doubtful.
Well, my lord, in this particular case, and I think we've given the details in our main skeleton, I'll be given the references. So far there have been 3 of these interim licence applications, and they have respectively taken 2, 3 and 3 days, I think, to determine at first instance. And in all of those cases, there was evidence on multiple bodies of foreign law. And we've given the references, and I can come back to that. Aided by the fact that in none of these cases have the foreign law experts in fact been cross-examined. Now, of course, if my learned friend wishes to cross-examine here, 2 to 3 days is more than enough to have a half a morning of evidence on foreign law. And I do emphasise that what is really going on here, the court needs to have an eye on this in my submission, is that every effort is being made to secure the outcome that Amazon is exposed to as many injunctions as possible, as quickly as possible in major markets, so as to force it to pay what Nokia is asking for, rather than being able to participate in the only trial that will actually determine RAND in any of these proceedings anywhere in the world. And the case management arguments about the interim licence need to be seen in my submission in that same context, my lords. My apologies to Mr. Moody-Stewart. I had indicated that I would finish at 12:45. I haven't. That is, I think, largely because of the slightly unexpected discussion that we had about the CPR 3122-2 order. Naturally, no criticism in that regard, but I have, in fairness to Mr. Moody-Stewart, gone nearly 15 minutes over what I indicated.
And that takes us to, I think, 1 o'clock. And you're at the end of yours.
I am indeed.
So we'll break now and start again at 2 o'clock.
All right.